the first to know. Nsem-Pii TV.
Legal luminary. Lawyer Tsatsu Chikata. Ghana had the obo ni dinya. Na se nipa dodo na nim se in fact wabini ewo mrenimo. Not until recently ya kwada ya aba mrenimo bono left right center man lusu cases thanks to MPP lawyer with the lawyer Frank Davis ni ade etwe the form saa no a enka lawyer Tsatsu Chikata de emra no ankasa wabini ewo mu ye papa. He is an institution on his own, no doubt about that. Whether say open as and open as. Now he's made some emphatic statement with respect to the vacant seat controversy, and I am quoting him from myjoyonline.com and of Joy News on Facebook. Or say, the Constitution is the supreme law of the land, and the responsibility to clearly interpret articles of the Constitution lies in the bosom of the Supreme Court. Hence, all of us have a responsibility to respect the Constitution, respect the Supreme Court, and to ensure the enforcement of the interpretation of the Constitution as stipulated by the Supreme Court. If you try to defend the defenseless, you will be disgraced. The lawyer Tsatsu Chikata chiremua Ghana ye mamre fe the Constitution no eno ne emra kunyini kase e wasase so na emra mu no enhyehyeye da ho ne se eye Ghana Supreme Court nko a ene wo to me say obekyerekere ensem a ewo Constitution na Supreme Court wa kyekere mu awie no eye oman no nyina ya sodie se ye di buo ni die ebe masa nkyekere mu no any Constitution nsem a woka na ya hwe na ye de aye adwuma na wo ye wadwene se nkyekere mu na kyiri no chinchine anchine a wo begina defendi a wa hwe yi a woni begu ase. These are very strong words coming from a legal luminary like lawyer Tsatsu Chikata. Nene ensema lawyer Tsatsu Chikata eke epiemu e Supreme Court. Ebra lawyers for Alban, Samana, Kingsford, Bagbin try say at all cost ombe defend the new man stipulated no in the Constitution with respect to the vacant seat controversy. Na reho kwese the Bagbin lawyer say bre woko ne do baby Chief Justice ya me get through to kono justice get through to kono to for say lawyer to na chekire nsem wo de nsam no we ho dodo ukoka ha no abeka ha. It was very, very interesting times in the Supreme Court today. Yanko kwanya Bagbin lawyers far so brave trying to defend what cannot be defended, trying to defend what the Constitution clearly spells out that it should be done.
All right, by court, no representation for Speaker of Parliament. We note also that the Speaker of Parliament has not filed any statement of case or memorandum of issues, despite the opportunity given for them to be filed. This matter is for hearing this morning. Can we hear counsel for the plaintiff?
My Lord, plaintiff filed a writ on the 15th.
We've noted all that you filed.
Okay.
If you don't mind,
Okay.
spend fewer than 5 minutes, because we've noted the memorandum of issues and the matter set out.
My Lord, I will just argue, I will simply argue that any rule of interpretation that is used to interpret Article 97(1)(g) and H will lead to one conclusion, with the accuracy of mathematics.
No. Any rule of interpretation used to interpret
Articles 97,
Yes.
1G and H of the 1992 Constitution
Yes.
will lead to one conclusion with the accuracy of mathematics. That conclusion being that the intention of the framers of the Constitution was that the intention of the framers of the Constitution was that the act that grounded the vacation of office.
Did anyone vacate any office?
Pardon me?
Did anyone vacate any office? Let's stay true to the records.
Yes.
Please stay true to the records.
But on the ruling of the Supreme Court, that certain acts should be deemed to be a vacation of the office. The ruling of the Speaker, sorry. That certain acts.
Please listen to yourself, Ms. Agati.
Yes, please. The ruling of the Speaker.
Ms. Agati, listen to yourself.
Yes.
And speak concisely.
Okay.
We don't want any confusion this morning.
My Lord.
Is what you are going to say materially different from the articulation of that point in the statement of case?
What I'm saying articulates or amplifies what we said in the statement of
But
case.
except for your adding that it should be construed with the accuracy of mathematics,
Yes.
which has made me apprehensive because this is social science.
Yes.
You must be mindful of what you are saying. This is social science.
But
That's why I'm asking whether what you are saying has not been captured in the statement of case. For which reason we can adopt and we can then express ourselves.
my Lord, just that you adopt the statement of case, but to assist in your apprehension, I agree that this is social science. But my Lord, in this case, if it is interpreted in any other way, it will need to have validity. And the courts frown on that. That is our submission.
You are really believe that that is better advocacy
Yes.
than what you earlier said.
I agree with you, my Lord. So this is social science. But any interpretation, any of the rules of interpretation, any of the rules of interpretation will lead to one conclusion. My lords, Article 97 was talking about one term of parliament, a particular term. 97 of vacation of office was talking about events happening in one term of parliament. And my Lord, therefore, Article 97, 1G and H will only take effect, or will only take effect if the act, that is the person, if the act, that is the person leaving a party by which was elected to join another party. Or to remain, or to become independent and seeks to remain in parliament without new political coloration, so to speak. If the person leaves the party for which he was elected into parliament to join another party or to become an independent member of parliament, seeks to remain emphasize that.
I don't think we need emphasis, Mr. Gatti. It's here, we'll read it.
My Lord, as directed by the court, I think our statement of case is self-explanatory. My Lord Tanko seems to be very happy. But as directed by the court, I think our statement of case is self-explanatory. And the purpose of this article will be undermined if it is given any interpretation other than the interpretation that has been given by the plaintiff. Thank you very much, my lords.
Honorable Gatti, just one point of clarification. Your relief 2.
Yes.
Is it still being maintained?
No. So our reliefs, some of our reliefs have been overtaken by the 10 of events.
Yes.
So we are relying on our relief 1.
Okay.
Simply.
Okay. So your relief 2, you are abandoning it?
Yes.
Okay.
The intention has become moot.
Okay.
It has become moot, my lord. Okay. This was found before the ruling was made.
Yes. So we needed to hear from you on that one.
Okay.
I thought that is where you would have made articulated that point.
Please. My lord, we only are relying now on relief 1, A, B, and C. They are all taken over by bench. Only 4. The omnibus clause, any further orders. Only 4. So 1, A, B, and C, and 4. Yes, sir. Well, most beautiful.
Thank you. Yes, indeed, I respectfully would like to advert the court's attention to Article 93, clause 1 of the Constitution. First, I would respectfully that even though the Second Independence sets out 3 issues for consideration by the court, my respectful view is that the first issue that we set out for determination, which is that whether or not plaintiffs will properly impose the resolution of the court, has in effect been disposed of by the court in its ruling dated the last agenda date.
Not entirely.
Right.
Be assured that it will be fully addressed.
Very well.
Not entirely, yes.
But the point I make is that on account of the argument advanced in court on 30th October 2024 and the ruling dated 30th October 2024, we did not find necessary this morning to go on with arguments under the first issue. They did rely on the arguments with the last agenda date. Respectfully.
No, you cannot proceed like that. You cannot proceed like that because the last agenda date, this panel did not hear you.
Right.
This is the panel that's hearing the substantive issues.
Yes. Right.
Yeah.
Consider yes. The ruling.
And I also wondered what you were talking about. I was not on that panel.
So 2 members have been added. Yes. So I'll then quickly deal with issue 1. The point to consider under issue 1 respectfully is that insofar as any matter borders on an interpretation of the Constitution and an enforcement of the Constitution. Same is within the exclusive preserve of the Supreme Court. Article 2, Clause 1 makes this quite clear. And Article 130, Clause 1 reinforces it and indicates clearly that this principle is subject only to the High Court's jurisdiction in the enforcement of fundamental human rights. Article 130, Clause 1.
The High Court's jurisdiction
in an enforcement.
In the enforcement of fundamental human rights.
And that's chapter 5. Especially, even the formulation of Article 130, Clause 1 indicates that insofar as an issue of interpretation arises out of a construction of any of the fundamental human rights provision, same will even come within the exclusive jurisdiction of the Supreme Court. That's one.
So even in the jurisdiction of the High Court on fundamental human rights, to enforce fundamental human rights, should there be a matter for interpretation that will come under the jurisdiction of the Supreme Court?
And I have as my authority the decision of the Supreme Court in the famous Nana J. Ampofo matter, which I have referred or cited in our Seymour case, and J. Ampofo versus Atendra. Again, it is reinforced by the decision of the court in Bedema.
Honorable Attorney General.
Yes, sir.
What you are telling us, is it not captured in your statement of case?
Yes, sorry, it is. I'm only addressing the court because my Lord Justice Tanko indicated at the last agenda date, those matters were actually not. I mean,
yes, but
this is the first time.
At the moment, we have your statement of case, all right? And that's what we are supposed to consider.
That's fine.
Good.
Yes.
So if it is captured in your statement of case, then you may spare us.
Right. So I will then proceed to the second issue. And in addressing the court to the second issue, I will refer the court to first Article 93, Clause 1 of the Constitution, which sets out the composition of Parliament. And says there shall be a Parliament which shall consist of not less than 140 elected members. This should be read as submitted respectively with Article 47, Clause 1 of the Constitution, which says Ghana shall be divided into as many constituencies for the purpose of election of members of Parliament as the Electoral Commission may prescribe, and each constituency shall be represented by one member of Parliament. Now, the combined effect of these provisions is that insofar as Parliament is constituted by a certain number of MPs or members of Parliament representing those constituencies, the composition of Parliament shall not be altered except as prescribed for in the Constitution. So no person or authority with all respect has the power to make any decision at all or construe the Constitution in a way which will alter or change the composition of Parliament except as stated in the Constitution. So I say that the matters before the court, apart from the meaning of Article 97, Clause 1, Paragraph G and H, also have an effect on the composition of Parliament as prescribed for by the Constitution. So I also further contend, respectfully. Right.
The combined effect of Articles 93(1) and 47(1) is that insofar as Parliament comprises of constituencies as set out in the Constitution, that composition cannot be altered except in compliance with constitutional directions.
Precisely.
That's the point made?
Yes, just a little point. Comprises members of Parliament representing the constituencies. Because Parliament is actually composed of the members of Parliament.
Noted.
Especially, I submit that the composition of Parliament can only be altered strictly in accordance with the Constitution. And no person or authority has the power to change Parliament as duly composed or constituted, except in accordance with the procedures known to the Constitution.